All right. Chapter 15, deeds. Okay, so why do we know in general about deeds? Why are deeds required? What are deeds?
How the title's conveyed.
That's our way of conveying real estate title. How do you convey a car? Car title. A little funky piece of paper. A boat, personal property, a little funky piece of paper that if it's a title vehicle with the county. But in real estate, we don't have that little teeny funky piece of paper. We have a deed, and then we have other things that get attached to our deeds. So it's a legal instrument conveying title to real property, required in everything we do. This is nationally. It's not just Ohio. This is a national way that we do real estate. We have different types of deeds. We have a warranty deed. This is a deed that conveys title and warrants that the title is good and free of liens and encumbrances. So we're out there trying to sell our property, and we're telling people we're going to give you a warranty deed, which means we're even going to warrant our title and tell you our title is so good that we're going to tell you we should be buying a title insurance and everything else. Well, in other parts of the country, that's exactly what they're doing. In Cincinnati, the buyers always said, well, we don't trust you anyway. We're going to buy our own title insurance. But the whole idea behind this warranty deed is it's a seller saying, I've got such a good property, I'm going to go ahead and I'm going to tell you that I can protect the deed and give you a good title. General warranty deed, full warranty deed conveys seller's title, contains covenants of title or warranties. There's 5 customary covenants. So it's covenants of season. The season, you might see this word somewhere else. Season is the covenant of the right to convey. The seller guarantees that his or her ownership of the property is in existence and they do have a right to convey. Covenant against encumbrances. Assurance that at the time of the conveyance, the property is free of encumbrances. This is an encumbrances that they know about. They haven't gone and done anything, signed paperwork or anything, except there's always utilities. So whether they like it or not, those encumbrances exist. But they haven't given somebody else the right to drive across their driveway to get the property behind. Or if those encumbrances exist, they're upfront about them. They're going to be showing on a title report. And the title company is going to say that these things exist with the property, and there's no way around them because encumbrances, easements run with the land. A covenant of quiet enjoyment warrants that the buyer will not be evicted by someone with superior title. In other words, we're going to protect your title. We'll defend against your title. Covenant of warranty, that the warrantor will defend against title of lawful claimants. And covenant of further assurances, that means the grantor will perform or do anything paperwork-wise that has to be done down the road. This could be 5 years, 10 years down the road, where they could come back and say, wait a minute, there's a title problem here. We've got to bring paperwork back, and we need you to sign this because we found a cloud in the title. We want a broken chain. We want to fix this. So this says we're going to do this. So this is a general warranty deed, full warranty deed. This is the best deed that we can get from any time we're buying property. It's what we've come to expect in the residential world, that we're going to get a full warranty deed. The special warranty deed or limited warranty deed restricts the extent of the seller's warranties. Anytime you're doing real estate with commercial properties, you can't give a full warranty deed. You can only give a special warranty or limited warranty deed. There's other reasons why in your lifetime that you'll run across things where you're not going to give the general the full warranty deed. But for most residential, we expect full. Other types of real estate, we expect special warranty or limited. The bargain and sale deed conveys title with no warranties. This would also be a sheriff's deed. No warranties. You're buying it from the sheriff's steps because there's a foreclosure action or we got it back on a tax sale, lien, or whatever, but we're selling on sheriff's steps. We're just going to give you a deed that lets you have title, but we're making no warranty about prior history. This is what investors buy all the time when they're buying property for sale on the steps. This is why we tell investors, go after you close, go get title insurance. It doesn't mean you're going to buy a title without problems, but you can at least have somebody investigate the title, and you can work on curing problems if we can find what the problems are. Quitclaim deed is an instrument that transfers the grantor's interest only, does not purport to convey title. So it's usually used in a divorce settlement. I said, when I first started selling real estate, one of the guys I worked with came to me and said, sign this deed. I bought a house with a friend of mine. I'm going to go buy another house with my wife, my family. All I want to do is get out. I don't want money. I'm quit claiming my deed. I don't want any more title interest. I want no more responsibility. So I want to give a quit claim deed to walk away from the property. A fiduciary deed is the person's placed by law in a position of trust. So we did fiduciary deeds, fiduciary responsibility, when I was a trust real estate manager. That's all we gave was fiduciary deeds for trust properties. Again, fiduciary. We're not going back in history. We're just saying we have the legal ability to give you title. So, essential elements of a deed. Kind of like a contract, we got to have certain things that are spelled out. We always have words of conveyance. So, include grant, convey, or bargain. We're going to give this, grant this property. We have to have competent grantor. So, it can't be a minor. Minors can sign deeds and will sign deeds, but they're voidable contracts. Much like a contract, the minor can sign a deed too. So one of the things we at a title company, you have to give your driver's license. They want to verify the people, the grantor, the people that are signing the deed have who they are, say they are, but they're also looking at the age to make sure that they're dealing with people that aren't minors. Mentally incapacitated. So evidence of the grantor's incompetency must be clear and convincing to cancel the deed for lack of mental capacity. We have people with dementia and Alzheimer's that have clear moments. You get that person to sign that title when they had a clear moment, and then a year from now or weeks from now, and they're no longer having clear moments, you may have issues trying to claim that they happen to have a series of great time where they could sign this or do this. This could be challenged. Corporations, special rules apply. What? Voidable. It's enforceable as business. Once the minor reaches majority, when they become 18, if they don't react in a certain period of time, they gave up all rights to cancel. They have to react in a certain period of time. So when that minor, let's say that minor was 18, they were 17 when they did the deal, and they're 25 now, and they realize they got screwed. I should have done that deal. I'm going to go back and say it's voidable. Sorry, you waited a little too long. So you would need to do it kind of like real soon after you reach majority. Corporations, special rules apply. Corporations have meetings, minutes of meetings. They have corporate resolutions that say certain people of the corporation are allowed to sign documents. When I worked at Ohio Casualty, it wasn't the CEO, it wasn't the president, it wasn't the controller. It was our treasurer that had the authority to sign all of our legal real estate documents. So I had a corporate resolution. That was for leases, that was for deeds, for everything. We had a corporate resolution. I kept that handy in my desk in a file because if somebody asked me for it, I had it available. 1 in 10 times that I signed leases, did somebody ask me, by the way, you're a corporation, where's your corporate resolution? So a lot of people weren't really investigating what they should have investigated. It was always available. I didn't volunteer it to anybody, but I had it available if they asked for it. Same thing when a corporation sells real estate. Corporations need to have the person of authority. Never assume that they're the president or CEO. They have the authority to sell real estate. Get the corporate resolution. So if you're dealing in commercial real estate, this is one of those things you learn to look and ask a few more questions about to make sure that you have a document that's good. You have a transaction that's good. Sometimes corporations may say, we don't have the authority. There isn't a person that has the authority. We may have to have a special meeting to actually have an action to sell real estate. So it depends on how it's set up, how the corporation is set up. Partnerships, you have Uniform Partnership Act that allows certain partners to sign things, general partners, things like that to sign. Identifiable Grantee. The deed does not convey title unless it names an existing identifiable grantee. So the deed can't name a corporation. Well, it can name a corporation, but there's got to be more about it that it's doing it. But you actually want to name something that you're granting it to, not just granting to John Doe. It has to be a living, existing type of thing. Adequate legal descriptions. Most courts interpret works of a description liberally in order to uphold a conveyance. In other words, if it's not totally accurate, they'll let it go through in order to let the conveyance go through. But we have fact checkers. We have people, title companies that are checking to make sure that the legal descriptions are written properly. Proper execution has to be signed by the grantor. Only the grantor signs. The grantee doesn't sign, but the grantee has to be named. They have to be at attestation. In other words, it should be witnessed by the execution of an instrument subscribing. Somebody's witnessing when they're doing it. Some states require the acknowledgement. I'm a notary. Some states require a notary or an attorney to actually acknowledge, and maybe another witness even to acknowledge. In most states, because I'm a notary, I can notary and witness. So if they just need one witness, my notary signature is fine. If they need two, I can be one, and then there's somebody else. General power of attorney, written instrument authorizing a person, the attorney in fact, to act as the agent. And by the way, if you ever want to be a notary in the state of Ohio, you read this little teeny pamphlet and you take a test and you're done. I was a notary in 1983. I haven't seen a book since then. I renew it every 5 years. It's no big deal. And you can only charge $2 now to be a notary. And if you charge too much, you can lose your notary. So I never charge anything. If you need notary, you need to tell me. I have a little kit I travel with, but it's in my desk drawer. No, I became a notary when I was the assistant manager of the Inquiry Building because all of our leases required notary signature. So they asked me to become a notary so that I could literally help our tenants sign leases. Delivery and acceptance. The deed does not transfer until delivered by the grantor and accepted by the grantee. So this is when you have these escrow closings and all these other things that are going on. Somebody still needs to deliver that deed to somebody. It can't just be shoved in a drawer. It needs to be delivered. Generally, it's thought of being delivered when you've recorded it, and then you deliver it afterward. But you still want to make sure that delivery happens. The escrow, again, process where money or documents delivered to and held by a third party until the terms and conditions of the escrow agreement are satisfied. But that escrow officer still records, still has to make sure they get delivery. What's the best way to do delivery today? Return receipt requested, but FedEx typically. We'll say FedEx is the easier, better way of doing it. But recently with the storms, I was trying to FedEx something a couple weeks ago and I couldn't get FedEx to work because it was a storm area. So I ended up sending out something certified mail because certified mail didn't know better. But certified mail takes longer. Certified mail can take a week to 10 days. FedEx, you know, you can do it overnight. But usually we just say we're going to FedEx something now to get it out. That FedEx, that may not be FedEx forever. It might be another delivery company. Deed restrictions. A condition in the instrument or covenant, a restrictive covenant. Restrictive covenants are provisions that limit the uses that may be made of the property. They're not a zoning kind of a thing. To get the property there, they're zoning anyway. Restrictive covenant may say you've got to have a certain color, certain style roof. You can't put a fence up. Or if you put a fence up, you have to have this kind. No RVs parked at the house. You know, those are restrictive covenants. How the land is used. You will find restrictive covenants in every type of PUD, planned unit development. You'll find them in the neighborhoods that have the little entry areas because these neighborhoods are part of a planned unit development. You'll find them in all condominiums. There's a restrictive covenant. I have tons of restrictive covenants at shopping centers because my restrictive covenants talk about users. You can't have certain kinds of users as long as this user's here, or you have to maintain these certain key storefronts or tenants can get out of their leases.
So if there are restricted covenants, is that still considered feasible absolute? Even though
yeah. Restricted covenant would still be fee simple absolute. You're still giving, they're buying the property. They're still getting title to it. It's just they're limited in how they can use it. And restrictive covenants, if they're written in a way that don't meet fair housing, they're no longer valid. My parents had restrictive covenants on their property in 1962 that they couldn't sell to a person of color. When fair housing laws came into effect, that's still in the history. That's still in the paperwork in there when I go back and research the history. But it's no longer valid. So the courts will never enforce that. So any kind of restricted covenant that doesn't meet those kind of requirements, the court will just strike it. It's no good anymore. Affirmative covenants typically are more positive. They talk about how you can build fences, how you maintain party walls, provide railroad crossings, join and pay dues. They're always more positive. That's why they're called affirmative. There are still requirements, whereas restrictions are generally negative. These affirmative covenants are more in the positive in how they're worded. But they do require annual assessment, homeowner association, maintenance facilities, things like that. So again, covenants, whether they're affirmative or restrictive, you'll find in every PUD, every condo, you have affirmative covenants as well. And then the covenants, conditions, and restrictions. Again, more part of it, commonly found bylaws of planned communities, operators requirements established by the ruling board. The purpose is to enhance and protect the value of the neighborhood as a whole, property value of individual parcels. So I worked with this guy, lived in this little neighborhood in Loveland. He was getting ready to paint his house. His next door neighbor one day saw him roofing and saw that he was going to paint. He was bragging to his neighbor about everything he was going to do. The neighbor said, hey, whatever you do, make sure you read this, because the guy on the other side of you belongs to the association. And as soon as you do something wrong, he'll let you do it wrong, and he's going to come and force it and make you do it right. So that's when he had to pull out all of his paperwork that he bought the house with to realize he couldn't paint the color he wanted to paint. He had to go back and change it. Fortunately, the neighbor advised him. Otherwise, he would have paid a painter to do it and paid a painter to come back and redo it. So those kinds of things exist, whether you know it or not. Something to think about when you people, you're representing people buying, selling houses. Where are they looking? What kind of neighborhood is it? Some of these neighborhoods aren't as obvious. You're usually, when you see the little wall that sets aside a neighborhood from another main road, that's a sign to everybody. Okay, where are the covenants? What do you belong to? What do you have to do as a result of living here? But some of those neighborhoods aren't as easy to identify anymore if they're older. Again, this is about a realtor doing their homework, knowing where these properties are. What are they? A few states have passed legislation that provides for elimination of these stale restrictions when they're old. The covenants can be terminated by release, by waiver, or by abandonment, but the methods are usually impractical. So once these covenants are established, it's very hard to get them removed. And that's it for deeds. Any questions about deeds, warranties?
That's a question. It's one of the study questions. It says, what's the effect of a purchaser's failure to record a deed on the purchaser's title and subsequent purchaser relies on the seller's recorded title? So I'm assuming if the purchaser moves in, then that's constructed. You know what I'm saying?
He's given notice. He moved in, but the recording of the deed is actual notice to the world.
So if he doesn't, so it's saying that the purchaser's failure to record the deed, how's that going to then affect eventually when he goes to sell?
Oh, I got it.
It could make it hard for him to sell because they can't prove that it's his.
Okay.
Is that the question? Is that the answer? Is that the question? Mm-hmm. Number 3.
Which one was it? Number 3, which one?
Number 3.
15, number 3.
381.
Thank you. Yeah, he could have a hard time trying to transfer title again. And what he needs to do, so he didn't record it when he moved in. It's 10 years later, find the damn paperwork and get it recorded. And that's where title companies, you lose paperwork, title companies should be able to find the paperwork for you. That's another reason for having title insurance. Somebody has paperwork somewhere that you can find.